Because I'm going to tell you, I'm a bit livid. Just a bit.
You take that up with her.
Well, I interjects herself, and quite frankly, interjects herself in a way that for an attorney to do it, if Ms. Toper were representing you, she shouldn't be filing anything with the court that you have not reviewed or she has not gone through with you and you have not seen. I'm going to set an order to show cause for Donna to show cause why she should not be held in contempt for the filing of this beyond this case.
Your Honor, we're here for our 7th hearing in this matter. If you recall,
And you might be to 10 by the time you guys get done, but go ahead.
By the time this 7th hearing begins, the tension inside the courtroom is already obvious. The judge sounds frustrated before anyone even starts arguing the substance of the dispute, and that matters because judges rarely show irritation this early unless procedural problems have been building for a long time. What makes this moment especially serious is that the conflict is no longer only about repairs, filings, or settlement talks. The court is now focused on something much larger: whether documents are being submitted properly, whether parties understand what is filed in their own names, and whether attorneys are crossing ethical boundaries. You can already sense the judge preparing to examine not just the facts of the case, but the credibility of everyone involved.
but at the last hearing, we had our motion. It was a motion hearing.
Yes.
And you stopped it, and it essentially became a settlement conference.
Yes.
Nothing came out of that. It didn't settle that day. After that hearing, the tenants sent 2 notices of repairs, which one of them matches one of the pending motions that's before you. Our response to that motion would apply to the second notice of repairs. And Your Honor, also, I learned on Friday afternoon, I received an email from Donna Toe with the filed correction of defendant's response to plaintiff's motion for summary disposition that was filed on her behalf.
You received what?
I received an email from Donna Toe with what appears to be, and it's a filing. It's called Correction of Defendant's Response to Plaintiff's Motion for Summary Disposition that was filed on her behalf.
That was on Friday you received it?
I received that on Friday afternoon. And this took
No, I got there.
I may be able to correct it.
Hold on 1 second.
Your Honor, I also have the email from this attorney, which it appears like she's still representing.
You know.
Oh, there it is.
January 14th. They just threw it in the plan. All right. Okay. I did not get a judge's copy of it. I'm just. So,
This is where the hearing starts shifting into dangerous territory for the defense side. The judge is no longer simply listening to competing arguments about motions or affidavits. Instead, he is trying to determine who actually authorized the filing that suddenly appeared before the court. That distinction is critical because courts rely on accountability at every stage of litigation. If an attorney files something on behalf of a client without proper review or authorization, the issue stops being procedural and starts becoming ethical. Notice how the judge repeatedly asks whether the defendants actually saw the corrected affidavit before it was filed. That question may sound simple, but legally it becomes the foundation for possible sanctions, contempt findings, and questions about professional conduct.
Hey, go ahead. I scanned it, but it's basically her affidavit, it looks like.
Your Honor, it appears to be a supplemental corrected affidavit by Ms. Tope. It's blamed on a computer glitch from the previous affidavit that she filed in response to landlord's MSD. I have many problems with the filing. At December 19th hearing, you ordered a moratorium on plaintiff's motion or party's motion practice, and it does not appear that they asked you for leave to file this corrected response to our MSD. Tope filed this on behalf of Wards, even though she was required to withdraw from this case, and she did withdraw from this case. Tope's filing in her email, which, again, I have the email, which demanded a copy of landlord's MSD, so it appears that she's still acting as counsel on behalf of the tenants. And tenants are responsible for their filings. They can't plead ignorance to this. The filing and Tope's affidavit are dated January 8th. That's 2 days after our last hearing. The proof of service falsely states that it was filed with the court and served on landlord on January 8th. The court stamp shows that it was actually filed on January 14th. And again, I didn't receive a copy of this filing until Friday afternoon, right before MLK holiday. Your Honor, I can address the substance of this corrected affidavit. It appears that she's still making the same residential lease argument that, as you recall, Your Honor, you warned the tenants that if they continue to make this argument, that they could be subject to sanctions. They made the argument, and they continue making the argument.
I need to deal procedurally, I guess, before I get to the substance of it.
I can address this.
Well, yeah, I know you can, but I want to try to figure out why this is here.
Okay.
You want me to address it?
Yeah,
I
please.
had no idea as to procedurally. All I did when we left is said, your affidavit was like glitched, incorrect, you've got stuff. And so I didn't ask her to do anything. She's not representing us. She just said, hey, just so you know, I fixed my affidavit. And that's as a witness, not as a lawyer. So what she says in her affidavit as a witness, I didn't have anything to do with it, and I didn't even realize it would be an issue. I told her that her affidavit was not correct at all, and that is how she followed up. She is not representing us, Your Honor.
This doesn't make much sense to me as to why she did this. He's not here to answer.
I have the email, which it appears that she's still acting on your behalf in this case.
Hold on a second. Can you show, were they CC'd on that, do you know? Or
Yeah.
can you show them, and then I want to see the email. There's time machines.
It's refiling. I just think it's a refiling of the original one with the correct affidavit. So I don't agree
Okay.
with the of the law, but to me, it just looks like a corrected, something that she had already filed. Actually, the correction to what we filed. You're gonna file.
The judge's frustration here centers on one issue: wasted resources. From the court's perspective, every unexpected filing forces opposing counsel to spend additional hours preparing responses, increases costs for clients, and consumes valuable courtroom time. What makes this especially serious is that the defendants themselves admit they never fully reviewed what had been submitted in their names. That creates a legal and strategic nightmare because accountability still attaches to the filing regardless of whether the parties carefully examined it beforehand. The court now has to determine whether this confusion resulted from miscommunication, negligence, or something more troubling. And once that doubt enters the record, every future action in the case becomes far more scrutinized.
Mr. Ward, I guess it would be one thing if you had filed something saying, here's the corrected affidavit. And if you went to Ms. Tope and said, this is all wrong, here's the corrected affidavit, and you guys sign off and you file. That's one thing. This is a whole other thing. And when you take it in the context of that email, I don't know why she's still communicating with counsel. It doesn't make any sense to me.
Did not ask her to do that at all. And I understand what you're saying. It would have made sense for her to correct her affidavit and hand it to us so that we could submit it. I have no idea why she did that.
So here's where we get into another thing. She filed this without your permission.
Yes. Believe me,
Have you
staying as far away from
have,
as possible.
did you read the affidavit?
The initial one,
No, I understand the initial one. Did you read this document?
no, actually, I didn't. I did not.
I did not know.
Updated, I mean,
Updated one.
because I didn't even realize that usually when we submitted something that had pages mixed up.
Your Honor, they're still responsible for their filings.
Yeah, but I don't know if that's their filing.
She mentioned about the pages being mixed up. Their response to our MSD, they are still responsible for their filings. That's all.
No, I understand that, but I don't know how I hold them responsible for things that were filed without their knowledge, is what they're telling me. That's the difficulty I'm having, right? Is that procedurally, if Ms. Tope came along and filed this, but had gone to them and said, here, this is, I see what you're saying, so I need to correct this, here's this, I'm going to file this. That might be one thing, but that's not what I'm hearing here. I'm hearing that this was filed, you guys didn't have any knowledge as to its contents.
Correct. I did know that she corrected it after the fact and submitted it after she did it. I had no idea any implications that would come of that.
You had knowledge that she did what?
That she fixed it after the fact, but she never told me that she was.
What does that mean? That you had knowledge that she fixed it after the fact?
She told me she did it after she sent it to them, but it was already done. She never asked me if she could do it.
So after. When was that?
At some point after they received it.
He just got it.
We received it Friday afternoon. Even though it's dated on their January date.
Yeah, I would have to look. I don't know.
And then
You have to look at what?
My email.
Look at your email. I want to know. Need 14 days for an article of house.
I think so. Yeah. Actually, there's nothing in here, so she must have just told me that she would fix it. If this is any help in understanding my brain frazzle, I also have a case of strangles at the farm.
What?
If this helps you understand my brain frazzle, I also have a case of strangles at the farm.
Okay.
Your Honor, I would add in the context that Ms. Toke is still representing them in the circuit court action.
Yes.
My understanding was that we were here today to continue settlement talks and that the settlement that we
ma'am,
presented on the 6th was rejected.
Right.
Okay.
We might be. And I may have called the parties back and said, look, where are we? I mean, counsel kind of let me know where his client, but the problem I'm having and what is creating a bit of a difficulty here is that there are documents that are being filed in this action, not by you.
Or with my permission. I don't know how I.
It's 14 exact.
Yes.
Was there anything recently filed in the circuit court action?
No, Your Honor. Yes, our witness list. Yes.
Right, okay, but I mean, anything else by Ms. Tote that was,
I filed my witness list and then she filed her witness list hours after.
right?
I could find that date. But to my knowledge, Ms. Tote is still representing the wards in circuit court action. And it seems like they were still having communication in this case.
Yeah, and the communication I don't necessarily have a problem with. What I have because I don't know that I could stop that anyway. But what I do have a problem with, so things are filed before this court, presumably on your behalf, but without your knowledge. That just it. And then counsel has to spend time looking at it and trying to respond to something that you guys didn't file. And you don't even know what it is at this point. No, I don't think either one of them said they've seen it before today. Did you see it? Yeah.
We talked about it, that he was updating it, but neither one of us read it.
No. I get that there can be these conversations,
Yes.
right? I mean, and I don't have a problem that she was going to update whatever.
Right.
Have you seen what was filed in court on your behalf?
No.
Do you know where Miss Tope is right now? Because I'm going to tell you, I'm a bit livid. Just a bit.
You take that up with her.
Well, I intend to, but here's the problem. Yes, I don't think the parties, and I'll just say this on the record, I don't think the parties were all that far apart in terms of how this matter could be resolved. That's just as court's view. But I also have these motions before me that I need to rule on. But at each and so we come back here, regardless of what the parties thought may happen, might not, whatever, right? She then interjects herself, and quite frankly, interjects herself in a way that for an attorney to do it, for anybody to do it is a bit appalling. For an attorney to do it is tenfold that. Because in effect, let's look at it this way. If Ms. Tope were representing you, she shouldn't be filing anything with the court that you have not reviewed or she has not gone through with you and you have not seen. But she's now filed something not as the attorney on your behalf, and you have no idea what it is.
Now the hearing reaches its most dramatic development. The judge officially announces an order to show cause, meaning the attorney may now be required to appear before the court and explain why she should not be held in contempt. That is a major escalation. Contempt proceedings are not routine procedural disagreements. They signal that the court believes conduct may have crossed a serious legal or ethical line. The judge also makes it clear that sanctions and attorney fees could potentially be awarded because of the additional time and expense caused by the disputed filing. What began as a disagreement over affidavits and procedural corrections has now evolved into a direct examination of credibility, authorization, and courtroom ethics.
You can't respond to her affidavit.
As a witness, I thought, because she was a witness to the
No,
issues.
but the affidavit is submitted as part of a motion for summary disposition. So if we go forward with the motion for summary disposition, you don't know what that says. Right?
Right. I mean, I have a general idea, but no. Specifically, no.
You don't know what it says. The only general idea you may have is what Miss Tope in the moment told you she was going to do. But you don't know what it says, do you?
No, not specifically.
So if I have counsel respond to the substance of this affidavit, I just want to be clear. You can't respond to the substance of what's been filed.
What makes this courtroom hearing so remarkable is how quickly a property dispute transformed into a deeper battle over legal accountability and procedural integrity. Throughout the hearing, the judge repeatedly focused on one core issue: whether filings were being submitted without proper client review or authorization. As confusion mounted over the corrected affidavit, the court became increasingly concerned about credibility, wasted resources, and the possibility that ethical boundaries may have been crossed. By the end of the session, the judge not only delayed the motions once again, but also scheduled an order to show cause hearing that could expose the attorney involved to sanctions or contempt findings.